And tonight on PM Express, a conversation that started in December after the 2020 elections. The Assin North MP Joe Jachikwesin was sued by an Assin North resident who claims he is a citizen of Ghana and of Canada. In January, the court issued an injunction barring the MP from being sworn into office as Member of Parliament. The minority disagreed, and the clerk finally allowed him with a warning that Jachikwesin will face the consequences. You followed what happened that night, and you know what I'm talking about. Today, the Cape Coast High Court has declared his position vacant. What does this mean for his party? What does it mean for consensus building in Parliament? Because the minority has already been reacting to this judgment. What does it even mean for our justice system and the laws that govern our elections? So let me help us refresh our minds on what has brought us here. And that is why we asked that question: what next for the Assin North case? You may all have followed that a Cape Coast High Court has announced the results of the 2020 parliamentary elections in the Assin North constituency today. The court, presided over by Justice Kwesi Boakye, ordered for fresh elections to be conducted. Now, residents of Assin North, Mr. Michael Ankuma Nimfa, and he's the one who brought us here. He filed a parliamentary election petition challenging the eligibility of Mr. Kwesin to be a member of parliament. The petitioner claims Joe Jachikwesin, at the time of filing to contest the 2020 parliamentary elections, had not renounced his Canadian citizenship. Now, the Assin North MP, before the judgment, filed processes at the Supreme Court and the Court of Appeal, but both processes were dismissed. Now, there's been reactions after this judgment was given this afternoon. The NDC has described the judgment of the court as a travesty of justice and has vowed to use all legal means to seek redress. The NPP, on the other hand, describes the judgment as one that vindicates the NPP's position. We'll be interrogating these two positions taken by these two major political parties. But also, constitutional lawyer Professor Assin contends the judge erred in interpreting Article 94, Clause 2A of the 1992 Constitution and compounded the error by equating allegiance to citizenship. A director of Diaspora Affairs Directorate at the Presidency, Akwesi Abebio, has implored Ghana's Parliament to, as a matter of priority, repeal Article 94, Clause 2A of the 1992 Constitution. Now, these are the facts of the case. During the election in 2020, the parliamentary election in Assin North, Joe Jachikwesin, who represents the NDC, garnered 17,498 votes. His contender, Abena Drowa Mensah, who represents the NPP, garnered 14,793. Now, the facts remain. The judgment was supposed to have been delivered on Wednesday, July 14, but the court adjourned the reading of this judgment to today because the MP, Jachikwesin, had petitioned the Apex Court to arrest the judgment of the court. Joe Jachikwesin invoked the supervisory jurisdiction of the Supreme Court for the court to interpret certain constitutional provisions that they believe the High Court was not competent in interpreting. And if you've been following the case in court in Cape Coast, you will realize that his lawyers have been mentioning and talking about this one. The application was later withdrawn in the Supreme Court on Tuesday, paving way for the judgment today. And the question tonight: after the judge announces the elections and declares for fresh elections, what next? That's what we'll be finding out in our conversation tonight. Joining me tonight for this conversation is Sami Jemfi. He's a National Communications Officer of the NDC. And joining me also tonight is Gary Nimakumafo. He is a member of the NPP Legal Committee. And thankfully, all the way from the US, Professor Assin, who is CDD Fellow in Public Law and Justice, is also joining me. I'll be getting to talk to all these gentlemen shortly after this break. Stay with me. And I'm grateful, gentlemen, that you joined this discussion today. Let me begin with you, Sami Jemfi, because you say the judge erred in law and in fact. Exactly which aspect of the law did he breach?
Thank you, and good evening to cherished viewers. The first point I want to make has to do with the shameful conduct of the registrar of the Cape Coast High Court and other judicial officers who deliberately frustrated lawyers for Honorable Kwesi from filing the necessary legal processes to compel the trial judge in this matter to refer certain constitutional questions that have arisen in the course of the conduct of this matter to the Supreme Court for determination. You would recall that yesterday, lawyers for Honorable Kwesi, when they appeared before the Supreme Court, were advised by the court to raise the constitutional issues they had brought before the Supreme Court in a formal application before the High Court and get the High Court to rule on same before applying to the Supreme Court if they felt dissatisfied with the decision of the trial court. So in line with that advice, the lawyers for Honorable Kwesi and the leadership of the party were at the registry of the High Court as early as 8 a.m. this morning to file a formal application urging the trial judge to refer the constitutional issues that have arisen in the matter to the Supreme Court. Now, it is instructive to know that the registry of the courts opens at 8 a.m. But today, even as at 9 a.m., the registrar officers in the filing room and in the registry were all not at post. And all efforts to get them to open the registry for us to file the necessary legal processes proved futile. So this was a well thought out, deliberate ploy or agenda by judicial officers who are paid by the taxpayers' money to do their work independently, impartially, and professionally to, manipulate the processes in favor of the party. And we think this is shameful. It is a matter we intend to pursue by lodging a formal complaint with the judicial service so that these officers can be disciplined. But having said that, let me demonstrate to you why, in our opinion, we think that the trial judge erred in law. You see, this whole case is about the issue of when a person is required by the Constitution to renounce his allegiance to a country other than Ghana before that person can contest as MP. That is the issue the trial judge, set down for determination in this matter. The case of the petitioner and the MPP is that requirement must be fulfilled at the time of nominations, in line with the Supreme Court decision in the Zaneto case. On the contrary, our position was that that requirement must be fulfilled at the time of the election of that person to the office of MP. And the trial judge basically said that, look, even though Honorable Kwesi, per the evidence before him, applied to have the citizenship of Canada renounced or to renounce the citizenship of Canada as far back as December 2019, he had not received his certificate of renunciation by the 5th to 9th of October 2020 when nominations were opened for parliamentary elections. And so he was not qualified to have filed his nominations. So in spite of the fact that he got his certificate of renunciation on 26th November and had seen before the December 7th election, and even before he was sworn in as MP, the trial judge says, you are still not qualified. Now, we think the judge erred because, number one, if you look at the grounds under which a high court can annul a parliamentary election, set out, under Section 20 of the Representation of the People Law, PNDC Law 284. What that section says is that the High Court can only annul a parliamentary election if a candidate is not qualified to contest the election at the time of the election. At the time of the election, not at the time of nominations. Bear in mind that under Section 11 of the same law, PNDC Law 284, the lawmaker has made a difference, has stated a clear difference between nomination and election. And so if the lawmaker was minded or intended to say the person should have been qualified at the time of his nomination, the law would have stated so expressly. But in this case, the law said the person must be qualified to contest for the election at the time of his election. And we are saying that the election was on 7 December 2020. Mr. Assin applied to renounce his citizenship of Canada in December 2019 and got his certificate of renunciation on the 26th of November 2020, before the December 7th elections and before he was sworn in on 7 January 2021. So clearly, he was qualified to contest as MP, and the judge had no basis in law to annul the election. The judge said that he takes the position that he was supposed to have renounced his citizenship by the time of nomination because the Supreme Court says so in the Zaneto case. But my sister, in the Zaneto case, what the Supreme Court was called upon to determine was Article 94 plus 1A of the 1992 Constitution. And the issue the court determined was, at what point can a person be declared as unqualified to contest as member of parliament for non-registration? Because 94 1A talks about a person being a citizen, being 21 years and above, and being a registered voter as a qualification to become a member of parliament. But the Honorable Assin case, this Assin case, it's not about this article. It's about allegiance to a country other than Ghana, provided under Article 24(2)A. So it is our position that the Supreme Court did not interpret Article 24(2)A in the Zaneto case. Okay. And that same should have been referred by the court to the Supreme Court for interpretation as prescribed under Article 131 and 2. It is so clear that this whole petition borders on questions of interpretation and enforcement of the Constitution, which falls within the exclusive jurisdiction of the Supreme Court. And that is why we sought to, urge or pray the court to refer that constitutional matter to the Supreme Court for termination, but the court failed to do so. So the court applied a decision of the Supreme Court relative to non-registration of a person to a matter which has to do with allegiance. The two are materially different. The spirits of these two provisions, in my humble opinion, are also different, because whereas somebody can argue that, in order for somebody to be qualified to take nomination forms to contest as member of parliament, the person must be a citizen, first of all. The person must be 21 years and above, and the person must be a registered voter. That makes sense, okay? You need to fulfill that. That is fundamental. But if I am 21 years old, if I'm a citizen of Ghana, if I am a registered voter, but I hold the citizenship of another country, why must I necessarily renounce that before I pick the forms? When the law says in PNDC Law 284, Section 21D, that I am supposed to fulfill this criteria at the time of election. Because you see, what were the drafters of the 1992 Constitution trying to cure? What mischief were they trying to cure when they made this provision that one must have renounced his allegiance to a country other than Ghana before he contests or before he becomes a member of parliament? What were they trying to cure? Okay. The whole thing is about loyalty. We're trying to ensure indivisible loyalty of members of parliament to Ghana. And so my understanding of that, the spirit behind that provision is that in the opinion or in the mind of the drafters of the Constitution, they didn't want a situation where somebody will be sitting in parliament as a member of parliament, making laws for the people of this country, but loyal to another country. So that mischief can only arise after the person has been sworn in and has entered parliament. But if before the person's election, the person had already applied a year before that I no longer hold allegiance to Canada, I don't want to have anything to do with Canada. Before the election, he gets his certificate of renunciation. Before he's swearing in, he has his certificate of renunciation. Why do you say that just because at the time of the nomination you had applied but have not received the certificate, you are disqualified? We think that that was a totally wrong interpretation of the law. And finally, before my other colleagues come in, let me see that assuming without admitting, my sister, assuming without admitting that the judge is right, that one must have renounced his allegiance to a country other than Ghana at the time of nomination. The question I want to ask is this: does the nomination period constitute the time for picking nomination and submitting the nomination form alone, or it includes the time for challenging that nomination? Because in this case, the nomination forms, nomination was opened on the 5th of October, submitted on the 9th. But after submission, you go through a challenge process. Some concerned citizens in Assin North, after Honorable Kwesi submitted his nomination form, challenged his qualification. The EC sat on the matter after 9th October, the close of nomination. And by the time they were determining that petition, Honorable Kwesi had received a certificate of renunciation, presented saying, on basis of which the EC dismissed that petition and declared him qualified. So if you are even going to accept the position of the judge that you must be qualified at the time of nomination, we are saying nomination is not just the time the person picks the form and submits. It's not just that period. It includes the challenge process. So if at the time the court, or if like the Electoral Commission determined that Honorable Kwesi was qualified to contest, he had received a certificate of renunciation, then he was qualified. So clearly, the court lacked jurisdiction. The court should have referred this matter to the Supreme Court for interpretation, because that Article 94(2)(a) is ambiguous and lends itself to contrary interpretations.
All right. So let me bring in Professor Kwekwasari here, Prof. And we're still waiting for Gary Nimakun, who is a member of the legal team for the NPP, to join. But Prof, we are back here again. Allegiance and citizenship. You say the judge erred twice, coming to the conclusion he did. Why do you say so?
Thank you so much for having me. The first thing I want to state is that we've traveled this road before. I remember my friend Adamu Sankede, MP for Boku. He went through the same ordeal. And at the time, I believe the case was handled by Justice Christ. And I wrote an article then outlining the problems with Justice Christ's ruling. I characterized it as travesty of justice and a comedy of errors. And what we are seeing now in this judgment, which sometimes relies on Wikipedia, is travesty of justice and comedy of errors on steroids.
Why do you describe it so?
Yeah, I'm going to go there. The first question that I want to address is whether or not this judge even has jurisdiction to hear the matter. It is clear to me that he did not possess that jurisdiction. And if you read his opinion, the judge himself claims that the petitioner put a different interpretation on Article 94(2)(a) compared to the interpretation that the respondent had put on there. From the petitioner's point of view, Article 94(2)(a) means that a person who is a dual citizen is not qualified to be a member of parliament, not just is the person not qualified, but the petitioner adds even a time dimension. He's not qualified at the time that he picks up his nomination contest for MP. Then the respondent, the first respondent, the MP, if his interpretation of Article 94(2) is that indeed it has nothing to do with dual citizenship, because it talks about allegiance. It doesn't talk about dual citizenship. Right there, if you go back to a case in civil procedure, a very important case, it's called Ex parte Accusa. Ex parte Accusa teaches us that whenever parties put rival interpretations on the provision of the Constitution, a good judge certifies the matter as. By certifying as, I mean the person or the judge refers it to the Supreme Court for interpretation, because it's no longer an application of the Constitution or even an enforcement of the Constitution. It's a question of interpretation of the Constitution. The second test, or the second leg of Ex parte Accusa, is where the constitutional provision is ambiguous, imprecise, or unclear. And clearly, allegiance, after reading the 64-page report by the judge, nobody can tell me he knows what allegiance is. All the judge has done is to throw out allegiance and insert the word citizenship. But this is something that the framers could have done when they wrote the Constitution, but they chose not to do that. And that goes to your question: what is the distinction between allegiance and citizenship? Now, if the judge had taken the time to read the Constitution carefully, as well as to go through the history of this allegiance article vis-a-vis dual citizenship, he probably would not have found himself where he finds himself now. But if you go to the original Constitution, 1992, dual citizenship itself was not allowed. Dual citizenship itself was not allowed. But Article 94(2) was there. Article 94(2) does not talk about citizenship. It says a person is not qualified to be an MP if he owes allegiance to a country other than Ghana. And the old Article 8 says that if a Ghanaian acquires the citizenship of another country, he automatically gives up his citizenship of Ghana. So Article 94(2)A could not have been addressed to an empty set, because nobody was a dual citizen. The Constitution itself did not allow for dual citizenship. And it feigns credulity for reasonable people to think that Article 94(2)A, which was in place at a time when dual citizenship was not allowed, somehow bad dual citizenship, somehow was related to dual citizenship. Let me go to Australia, because Australia has one of the most stringent requirements on allegiance, dual citizenship, and so on. And I'm going to read how their framers wrote their constitution. Anybody can Google it. It's section 44(1). Section 44(1) of the Australian Constitution is in the form of the following: any person who is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, so that's one leg of the disqualification, or is a subject, a citizen, or entitled to the rights or privileges of a subject or citizen of a foreign power, shall be incapable of being chosen or of sitting as a senator or a member of the House of Representatives. But what is that telling us? It's telling us that they don't want you to be in their parliament if you owe allegiance to a country other than Australia, or if you are a dual citizen. So the two things are not the same. Let's come back to Nigeria. If you go to Nigeria and you read Nigeria's Article 66(1)(a), it says, no person shall be qualified for election to the Senate if he has voluntarily acquired the citizenship of a country other than Nigeria, or has made a declaration of allegiance to such country. Again, they make a distinction between allegiance and citizenship. Now, if you go to Ghana and you review our constitution from 1957 to date, there is always a statement on allegiance, such as we have now. But the 1957 constitution, every Ghanaian was a dual citizen, because the Ghanaian citizenship itself did not come into being until May 1957. Until May 1957, everyone who was then the then Gold Coast, comprised of the 4 territories, Gold Coast Colony, Ashanti, Northern Protectorate, and then the Transvaal, they were either subjects or protected persons of the British. And then when we gained independence and the nationality, the First Nationality Act was enacted, they became Ghanaians in addition to being British subjects. So everybody was a dual citizen. And yet, if you look at the 1957 Constitution, it had this language, because that language is from the Commonwealth, it's from the United Kingdom. That allegiance, and I will explain what it means, it's from the United Kingdom. In the 1960 Constitution, Nkrumah, who was very much against feudalism, because allegiance emanates from feudal law, eliminated completely any reference to allegiance. And that allegiance language was reinstated in 1969. The 1969 Constitution did not allow dual citizenship. It was reinstated in 1979. The 1979 Constitution did not allow dual citizenship. And then it was reinstated in 1992. The 1992 Constitution originally did not allow dual citizenship until we lobbied and Parliament enacted Act 527. It was Act 527 which allowed dual citizenship. And so the notion that allegiance is the same as citizenship is completely wrong. Anybody at all can Google, is allegiance equal to citizenship? There's a case in Philippines, there's a case all over the world. And you can find that it is wrong. Now, so the whole basis of the judge's ruling is that allegiance is citizenship. And once you understand that he got that wrong, there's nothing in the opinion that really anybody can do anything about.
All the options available to the MP, which one do you want him to take?
Oh, there's only one option, which is to appeal. He needs to apply for a stay and then send the matter upstairs to the Supreme Court. Because the Supreme Court has to tell us what allegiance means. Allegiance does not mean citizenship, because I've explained why. What does it mean? I'm going to guess what it means because I know a little bit about allegiance and I know a little bit about where it came from. Allegiance comes from a case in the 17th century. It's called the Calvin case. And the Calvin case was actually about whether a Scottish person can buy land in fee simple in England at the time when King James VI ascended to the throne of England. And Calvin basically says allegiance to a king is permanent and indivisible. Therefore, even though Calvin was a Scottish, he can still buy land in England because the king of England is now a Scottish. And I'm going to read, if you have the time.
Be brief. Let's just look at the what the court said.
Which court?
I mean, that case you talk about.
Yeah, I want to read because that's allegiance. This is from Blackstone. Blackstone says, natural allegiance is therefore a debt of gratitude which cannot be forfeited, cancelled, altered by any change of time, place, or circumstance, nor by anything but the united concurrence of the legislature. An Englishman who removes to France or to China owes the same allegiance to the King of England there as at home, and 20 years hence as well as now. For it is a principle of universal law that the natural born subject of one prince cannot by any act of his own, no, not by swearing allegiance to another, put off or discharge his natural allegiance to the former. For this natural allegiance was intrinsic and primitive and antecedent to the other, and cannot be tested without the concurrent act of the prince whom it was first due. The basic idea here is that allegiance is a one-time call. It is to your motherland.
Yeah.
You can have multiple citizenships,
okay,
but you can only have allegiance to your motherland. That's why they call the country of your birth your motherland. And one other problem in the decision, which follows from misunderstanding between allegiance and citizenship, the judge, for instance, confuses dual citizenship with dual nationality. Citizenship and nationality are different things. Citizenship is a legal concept. It relates to the reciprocal rights and duties between a state and its subjects. Nationality is a cultural concept. It is nationality which triggers these notions of allegiance and so on. And that's why somebody who, let me not even go there for now.
That's a very interesting breakdown for us. But Same, you've indicated that you will file a stay of execution and also take processes to appeal this decision. When exactly do you intend to do this?
As soon as possible. I think Professor Asare has clearly indicated that is the only option available to us under the laws of this country. And so we will be appealing this bad decision, which, in our opinion, is a travesty of justice which should not be allowed to stand. And we will be filing for a stay of execution pending that appeal. But let me state that I agree totally with the submissions of the submission of Professor Asare. For us in the NDC, this was a golden opportunity for the Supreme Court to once and for all settle the issue of citizenship against allegiance. And the High Court has denied the Supreme Court that opportunity. And the right thing would be for us to invoke the supervisory jurisdiction of the Supreme Court by way of an application for certiorari to quash this decision of the High Court and get the court to determine that constitutional issue. But that said, leaving that aside, assuming without admitting that citizenship is even the same as allegiance, which is not, I'm not admitting that I agree with Professor Asare. I'm admitting that the two are used. The point is that this man, Honorable Kwesi, applied to renounce the citizenship of Canada in December 2019. By the time the nomination period was concluded, he had received his certificate of renunciation. And when I talk about the nomination period, I'm talking about the period for the challenge of the filing of the nomination as well. At the time that was concluded, he had received his certificate of renunciation. At the time of the election, he had the certificate of renunciation. At the time of being sworn in as an MP, he had the certificate of renunciation. And so why would the judges rely on the decision of Zanetto in the Zanetto case by the Supreme Court without non-registration of a person and not about allegiance, and apply that decision in this case, So the court said,
I think we're still having challenges.
We will be doing the needful.
We're still having challenges with Sammy Jemfi's internet connection. We'll try and get him back on this one. But let's take a break on PM Express. And when we return, let's look at, already we'll be talking about how to bridge this gap of allegiance, citizenship, and what have you, because we've come to this conversation a number of times. I think there's time now for us to look at how we clear this confusion, because already people are calling for Article 94(2)(a) to be looked at again. What would it take for us to cross this bridge? Also, there are those who feel that the NDC did not put up a coherent legal fight, hence this outcome. We'll be getting answers to all of this after this break. Welcome back to PM Express. Remember to send your comments and tweet at us at the hashtag PM Express. Let's know what you think about this. But we're talking about the Cape Coast Court's judgment today on the Assin North parliamentary seats case, which has been going on for some time now. Sammy, you were making a point before the internet failed us. There are those who feel that you should have pushed harder because you did not put in a spirited defense.
I think those who say that have not followed this case, because if they have followed this case, then they will know that there is nothing under the sun that our lawyers were supposed to do, or lawyers for Honorable Kwesi were supposed to do, that they didn't do under the circumstances. If you have a registrar of the courts and judicial officers who are supposed to be professional and impartial, independent, in cahoots with the party in the if you go to the registry of the court, file an application at 8 a.m., which is the opening time for that office, and for reasons best known to the officers in charge, they decide not to come at work at 8, but come at 9 deliberately to frustrate you from filing the necessary application before the process. What can you do? So our lawyers have done a yeoman's job and they deserve commendation. But to reinforce the point I'm making, which Professor Asare has really expatiated in a very lucid way, is that even as we speak, a citizen of Assin North called McIntyre has invoked the original jurisdiction of the Supreme Court to interpret Article 94(2)(a). And one of the issues McIntyre is calling on the Supreme Court to interpret in that action is the issue of citizenship versus allegiance. And so clearly, the High Court lacked the jurisdiction to determine that matter. And like Professor Azari said, in one breath, the judge says, oh, this provision is very precise, clear, and unambiguous. But in another breath, it says that the parties to the case have put contradictory interpretations on that same provision, which he claims to be very clear, precise, and so on. So clearly, he erred in that regard. And I want to also draw our attention to something that our courts have not addressed, relative to this issue of citizenship versus allegiance, and relative to the issue of how one must renounce his or her citizenship. And here I am referring to the decision of the High Court in the case of Bilson versus Rawlings. You know that Mr. Belson sued Mr. Rawlings in 1992 on grounds that he was a dual citizen by virtue of the fact that his father was a national of the United Kingdom.
Yeah.
And his position was that he needed to show a certificate of renunciation before he could be deemed to have renounced his citizenship of the United Kingdom. But Justice Sylvie Bonzi, who presided over that case, took another view, that President Rawlings didn't need to show any certificate of renunciation before he can be said, or he could have been said to have renounced his allegiance. He said, this President Rawlings is a member of the Ghana Armed Forces. He has sworn an oath of allegiance to Ghana, both as a soldier and also as president of this country at different, times. And apart from that, the nomination form he filed to contest as president on the ticket of the NDC in 1992 had a statutory declaration in which he had sworn before a commissioner of oath and declared solemnly that he didn't owe allegiance to any country other than Ghana. So by virtue of the fact that Rawlings, as a soldier and as a former president, has sworn allegiance to Ghana, by virtue of the fact that President Rawlings had submitted a statutory declaration to the EC at the time, swearing that he owes allegiance to no other country apart from Ghana. Justice Sylvie, in that case, Belson versus Rawlings, said, whether he has a certificate of renunciation or not is inconsequential. Okay. That alone constitutes evidence of constructive renunciation. Why is it that now we are being told by our courts that until a foreign country issues you a certificate of renunciation of your citizenship of that country, you still owe allegiance to them? When you are a citizen of Ghana, you have sworn allegiance to Ghana, you have submitted a statutory declaration in which you have sworn that you owe allegiance to only Ghana. We are saying that until that foreign country accepts your application of renunciation, you still owe allegiance to them. What kind of interpretation is that?
Professor Kwekwa,
what kind of interpretation in that?
What exactly can be done on this dual citizenship matter to settle the issues properly, both constitutionally and outside the bounds of the legal system?
Excellent question, and we are working on that. In fact, we have a bill that has been gazetted, and the bill purpose is to eliminate all these restrictions. Article 94(2)(a), Article 8(2), Citizenship Act 2000, Section 16, and then the Office of Special Prosecutor Act 459, Section 13. We have presented a bill that intends to get rid of all these restrictions that include Ghanaians who have the citizenship of other countries. The thing that people do not realize with Article 94(2)(a) is that it's not just about if you owe allegiance to a country other than Ghana, you cannot be an entity. But it is also about so many other things, because I have a list here of things that you cannot do if you cannot be an MP. You cannot, for instance, be a minister of state. You cannot be a deputy minister of state. You cannot be a cabinet member. You cannot be a speaker of parliament. You cannot be a member of the electoral commission. You cannot be a member of the Public Service Commission. You cannot be a member of the National Commission for Civic Education. You cannot be a member of Lands Commission. You cannot be a founding member of a political party. You cannot be an executive member of a political party.
That's a tall list.
You cannot be a leader of a political party.
For the sake of time.
So the question then is, what really is citizenship? What does it mean to say you are a citizen of Ghana? You are a natural born citizen of Ghana, and you cannot be anything. Obviously, the scope of restrictions alone should alert us that we are misinterpreting Article 94(2)(a). My understanding of Article 94(2)(a) is that it applies only to naturalized Ghanaians or registered Ghanaians. This is the common sense approach that the Nigeria courts have used. The Nigeria courts insist that a natural born Nigerian cannot be excluded from the political space.
So clearly, Article 94.2 should be looked at again.
Be repealed, and there's a bill to that effect that has been gazetted that we are pushing through. I was in Accra about, I just arrived 2 days ago, trying to push this through back to make sure that we put finishing touches on it. And when it is done, we will grow past these things and move on to solving real problems, fixing the.
I'm grateful for your time, Professor Kweku Asare. He is a CDD Fellow of Law, and I must say that Gary Nimakomafo, who is a member of the NPP legal team, was supposed to join us. We sent him the Zoom link. He agreed to do so, but all calls to get him to join when the show started proved unsuccessful. But I want to say thank you to Sami Jemfi. He's a National Communications Officer of the NDC. Thank you so much, viewers, for watching. Enjoy the rest of our programs.